Hey everyone, welcome. My name is Nolan Klein, and I am a litigation attorney that has handled over 1,000 federal lawsuits at this point, and 300 or 400 of those cases alone have been website ADA cases. So if your business has been sued in a website ADA case in the past, maybe you're facing one right now, or maybe you're just trying to educate yourself to protect your business and implement really appropriate risk management strategies to avoid ADA website lawsuits in the future. This video will hopefully be helpful. In the past, I've done really very short videos explaining ADA lawsuits and the issues that cause them or that were alleged to have caused them. But here I want to go in detail through an actual complaint, like the actual lawsuit that would be served on the business by a process server. You know, they come like the movies, they say, here, you've been served, and they hand you the piece of paper. This is the piece of paper that they hand to you. Oftentimes people will call me and think that it's a letter or something other than an actual lawsuit, but it is an actual complaint filed in court. And this video really is applicable also to all different types of federal lawsuits. I'm going to talk specifically about the ADA, but we'll see the way the complaint is broken down in terms of the way it makes certain jurisdictional allegations about the parties, and then separates itself into separate counts. That is sort of the skeleton really for any federal lawsuit. But here in specific, in particular, we're going to be looking at an ADA website case that was recently filed, an actual case. We're going to look at the relevant allegations, and after this video, anybody watching it should be able to look at one of these lawsuits and know what they're looking at. It should be a little bit demystified and maybe a little bit less scary. Okay, so this is the lawsuit that I pulled up. I pulled this lawsuit up at random. I pulled it up from the Southern District of New York because a lot of website ADA cases get filed there, although many are also filed in Florida, in California, in the Eastern District of New York, and in other places all over the country. But the Southern District of New York is a place where a lot of these cases get filed. So I just randomly pulled this one up. And this case is styled Jacqueline Fernandez versus Food State Inc. Again, just completely randomly pulled this off of the Southern District of New York docket. This person, Jacqueline Fernandez, like a lot of people who file these cases, has filed a significant number of them. Here, let's pull up the PACER docket report for this person. So this is just within the public access to court electronic records. We can put in her name, and we can put in 446, which is the code for Title III of the ADA, which is what website lawsuits fall under, and we can see the number of lawsuits that she's filed. So this is someone who's filed a number of these cases, as is almost always the case with these lawsuits. So something that people will very often be surprised about or up in arms about when they call me is that they're being sued by someone who has filed dozens or hundreds, or in some cases, thousands of these lawsuits. But this is an extremely common occurrence. And we see here that this person, Jacqueline Fernandez, has filed a number of these cases. So back to the complaint. We are going to start with the introduction, and let's just work through this complaint methodically so that anyone who sees one in the future will understand exactly what it is that they're looking at.
Plaintiff Jacqueline Fernandez, on behalf of herself and others similarly situated, asserts the following claims against defendant Food State Inc.
Okay, so within this first paragraph, we know a lot. We know who the plaintiff is, we know who the defendant is, and we know that it's a class action complaint because she's filing it for herself and others similarly situated. That would be presumably other blind people who may have run into the issues that she alleges she ran into in this case.
Plaintiff is a visually impaired and legally blind person who requires screen reading software to read website content using the computer. Plaintiff uses the terms blind or visually impaired as plaintiff's central visual acuity with correction is less than or equal to 22/100ths.
Okay, so second paragraph, and the plaintiff is establishing that she's blind. And the reason she's establishing that she's blind is because that is the central fact in this case, other than her allegation that the defendant's website is not accessible to the blind. The most important allegation is that she is blind, because if she were not blind, then why would she be filing a case that alleges that the blind are being excluded from a website?
Based on a 2020 U.S. Census Bureau report, approximately 8.1 million people in the United States are visually impaired, including 2 million who are blind. According to a 2016 report published by the National Federation of the Blind, 2016 report, approximately 418,500 visually impaired persons live in the state of New York.
Okay, these are not necessary allegations in order to state a claim, in order to create a lawsuit or a complaint, in other words, that can be pending in court and won't be thrown out. But nevertheless, the plaintiff, for whatever reason here, and I see this a lot in these cases, is just establishing the number of people who are blind and visually impaired.
Plaintiff brings this civil rights action against defendant for the failure to design, construct, maintain, and operate defendant's website, www.megafood.com, to be fully accessible to and independently usable by plaintiff and other blind or visually impaired people. Defendants.
Okay, so here we get to the hub and the crux of what this lawsuit's about. Plaintiff is suing because she is alleging that the defendant's website that she names here is not fully accessible and independently usable by blind people. That is what this case is being brought alleging.
Defendant's denial of full and equal access to the website, and therefore denial of the goods and services offered thereby, is a violation of plaintiff's rights under the Americans with Disabilities Act.
Okay, so this is something that a lot of businesses and business owners that get sued have a problem with, this kind of language, that the allegation that the defendant is denying access or excluding, because obviously nobody's intentionally denying access or excluding the blind and the visually impaired. And so sometimes this kind of language is inflammatory, but this is very common language that we see in these complaints.
Congress provides a clear and national mandate for the elimination of discrimination against individuals with disabilities. Such discrimination includes barriers to full integration, independent living, and equal opportunity for persons with disabilities, including those barriers created by websites and other public accommodations that are inaccessible to blind and visually impaired persons. Similarly,
okay, I'm just going to pause here to say that I think that this, to me, in my opinion, this statement is not fully accurate, because the ADA itself, the ADA law itself, as we'll see a little bit later in this video, does not list websites within the definition of public accommodations. That's judge-made law. And so, in my opinion, it's inaccurate to say that the ADA prohibits barriers to websites and other public accommodations. I just don't think that a website is a public accommodation. This is a point of disagreement. But again, this is a very common allegation in these types of lawsuits.
Persons. Similarly, New York City law requires places of public accommodation to ensure access to goods, services, and facilities by making reasonable accommodations for persons with disabilities. Defendants' web.
So now, for the first time, this is discussing New York law. Now, that wouldn't be applicable to someone who's sued in another state other than New York, obviously. But in New York, the New York laws are often implicated, and the New York laws provide for damages and attorney fees and other things. So the lawyers who file these cases almost always, I don't think I've ever seen a case actually that did not have New York State and, if applicable, New York City law incorporated into it in addition to the ADA allegations.
Disabilities. Defendant's website is not equally accessible to blind and visually impaired consumers. Therefore, defendant is in violation of the ADA. Plaintiff now.
This statement of law, defendant's website is not equally accessible to blind and visually impaired consumers, therefore defendant is in violation of the ADA. Probably a true statement of law in the Southern District of New York. Not necessarily a true statement of law in other districts. Again, the ADA itself doesn't say anything about website accessibility, at least as of this recording, and neither do the implementing regulations. And so what we have are judges throughout the country that have applied the ADA to websites.
Plaintiff now seeks a permanent injunction to cause a change in defendant's corporate policies, practices, and procedures so that defendant's website will become and remain accessible to blind and visually impaired consumers.
So an injunction is what the ADA provides for. So this gets a little bit complicated, but under the ADA, a plaintiff can get two things. Number one, an injunction, and number two, legal fees. The injunction is an order from the court telling the defendant to become compliant with the ADA, and the legal fees obviously are the legal fees. New York law or California law or other state laws are often tacked on to these ADA cases because they also provide for damages. But where the plaintiff here is talking about a permanent injunction, you see this language in every ADA case of every type, certainly in every website case. They are asking here for the relief that the federal ADA would provide to them.
This court has subject matter jurisdiction over this action.
The court has subject matter jurisdiction in this case is the allegation. Subject matter jurisdiction is a topic for a very long, different video. But basically, in order to have a case in front of it, a court needs subject matter jurisdiction. That is to say, it needs to have jurisdiction over the subject matter of the lawsuit. So if the lawsuit is of a type that the court has no right to hear, then it has no subject matter jurisdiction and it cannot hear the case. So what the plaintiff is saying here, and in every one of these cases, is that this is a type of case that can be before this court. This court has subject matter jurisdiction over this case.
This court has supplemental jurisdiction under...
Okay, so supplemental jurisdiction gets us into the New York issue. So you will not see this allegation about supplemental jurisdiction in a case, for example, in Florida, where a state law is hardly ever part of any ADA case. You will see it in California cases, you'll see it in New York cases. Supplemental jurisdiction means that even though a type of claim is not a kind that could on its own be in front of a federal court, the court has jurisdiction to hear it because it is in addition to or supplemental to the matter that the federal court can hear. So in this case, for example, the federal court, of course, can hear an ADA case, and the plaintiff is saying that the court therefore has supplemental jurisdiction to hear the New York state law claims.
Venue is proper in this district.
Okay, venue this is another jurisdictional allegation. So you'll note we're going here through the plaintiff explaining to the court why this is the right court. The court has subject matter jurisdiction over the claims. The court has supplemental jurisdiction over claims that it would not otherwise have subject matter jurisdiction over. And venue is proper. Venue is the exact place where it's filed. So, for example, in New York, you have 4 federal judicial districts: Southern, Eastern, Northern, and Western districts of New York. This case was filed in the Southern District of New York, and the plaintiff is just simply saying that he filed or she filed this lawsuit in the right venue, in the right specific courthouse.
Defendant is subject to personal jurisdiction in this district.
Okay, personal jurisdiction is a complicated subject, and it's a subject that, with respect to these website cases, can get a little touchy. In New York, many businesses are sued because their websites were viewed or are used in New York, even though the business that actually runs the website, the business that owns the website, has nothing to do with New York. So under a typical personal jurisdiction analysis, if you are sued somewhere, the court looks to see whether it has the ability to rule over you. Do you live in the jurisdiction that this court is in? Do you have offices here? If you're a business, do you have employees here? Do you have agents here? Is the thing that did you do something in this jurisdiction that resulted in the lawsuit? These are the typical things that will give rise to personal jurisdiction. In these ADA website cases, though, there is generally personal jurisdiction, and again, I'm speaking specifically here about this New York district, where an interactive website was usable and viewable in New York. That is not necessarily true in other places. You will very rarely see an ADA website case against a pure e-commerce site filed in Florida against a non-Florida business because the courts won't have it. But jurisdiction by jurisdiction, district by district, there are little differences. And so in New York, this plaintiff is saying that subject matter jurisdiction is fine because the website can be used here.
Defendant has been and is committing the acts or omissions alleged herein in the Southern District of New York that caused injury and violated rights the ADA prescribes to plaintiff and to other blind and other visually impaired consumers.
Notice, by the way, continuing with this other blind, other visually impaired consumers, again, just reminders that the plaintiff is trying to set out a class action on behalf of more people than just herself.
A substantial part of the acts and omissions giving rise to plaintiff's claims occurred in this district. On several separate occasions, plaintiff has been denied the full use and enjoyment of the facilities, goods, and services offered to the general public on defendant's website in New York County. These access barriers that plaintiff encountered have caused a denial of plaintiff's full and equal access multiple times in the past, and now deter plaintiff on a regular basis from accessing the defendant's website in the future.
Okay, now remember what I said a minute ago. In New York, many businesses are sued from all over the country and all over the world. I've represented international companies that have gotten sued in New York that have no connection to New York. And the basis for it is this allegation that the plaintiff tried to access the website from inside New York. Again, not something that flies in all other judicial districts, but very common in the Southern District of New York.
Defendant's website and the goods and services offered thereupon is a public accommodation within the definition of Title III of the ADA.
The allegation here is that Title III of the ADA makes a website a public accommodation. I've already spoken about that just in this video 2 or 3 times already. Here we have Title III of the ADA and the definitions of what a public accommodation is. And there's a lot of things on here: a restaurant, a bar, a laundromat, a museum, a library, a gallery, an inn, a hotel, a motel. There's a very, very long list of places defined as a place of public accommodation under the ADA, but the word website is nowhere found in there, okay?
Standing. Plaintiff Jacqueline Fernandez is a blind, visually impaired, handicapped person and a member of a protected class of individuals under the ADA. Consumers such as the plaintiff may purchase defendant's products and access other brand-related content and services at the website defendant owns, operates, and controls. In addition to researching and purchasing defendant's products and services, consumers may also use defendant's website to sign up to receive product updates, product news, and receive special promotions not available elsewhere. Plaintiff was injured when plaintiff multiple times, most recently on August 29, 2024, to access defendant's website from plaintiff's home in an effort to shop for defendant's products, but encountered barriers that denied the full and equal access to defendant's online goods, content, and services. Specifically, plaintiff wanted to purchase nutritional supplements.
So now we get to this concept of standing, and I'm going to go through this as quickly as I can. Standing goes hand in hand with subject matter jurisdiction. It is extremely important. If the plaintiff does not have standing to bring the suit, then the court does not have subject matter jurisdiction over the lawsuit, and the case has to be dismissed. Let me get into this in a little bit more detail without getting too complex. The federal courts, Article 3 of the Constitution, federal courts exist to adjudicate cases and controversies. They are not there to issue advisory opinions. What do I mean by that? Well, the courts are there to resolve real disputes, like actual things that are being argued about and require a court order or court judgment to resolve them. The federal courts do not exist just to provide an opinion about things in an academic or hypothetical way. And so if there is no actual controversy before the court, then the court has no subject matter jurisdiction. It doesn't have the ability to hear the claim, and the claim has to be dismissed. So how does that relate to the concept of standing? If a claimant or a plaintiff has standing, then he or she is the person that's actually affected by the thing that's being complained about. So for example, if the plaintiff in this case wasn't blind, wasn't even alleged to be blind, but she was suing based on ADA violations that exclude the blind, that would not be an actual case or controversy because she is not excluded. That would just be asking the court to make a general determination on whether this defendant is violating the ADA, but not to resolve an actual dispute between parties who are before the court, more as just an advisory or academic matter. So by alleging that she has standing, the plaintiff is saying that she is a person that has an actual dispute with the defendant over the issues that are raised in this lawsuit, and that the court can issue an order that would actually resolve that real dispute, and that the court therefore has subject matter jurisdiction. Hopefully that wasn't too complex. It's a complicated subject, and frankly could be the subject not only of a video, but of a semester of law school. But that is a sort of 30,000-foot overview of why defendants, businesses that are sued in these cases will often see, sometimes without this heading of standing, that's very sort of, out there to put a heading that says standing. I mean, there's nothing wrong with it, but you don't usually see it that blatantly, but you will see allegations that establish that the plaintiff is the right person to have brought the case so that the case doesn't get dismissed for lack of subject matter jurisdiction.
Plaintiff wished to purchase this product because she was in search of nutritional supplements that could support her overall well-being. She intended to find a store offering a broad range of health-related products, with a focus on supplements made from natural ingredients, ensuring both effectiveness and responsible sourcing to promote long-term health. Plaintiff came across defendant's website via Google search. This website hold themselves out as an online store renowned for producing whole food-based supplements made with real farm-fresh ingredients, focusing on nutrient density, quality, and transparency in their sourcing and manufacturing processes. Unfortunately, plaintiff was unable to complete the purchase due to the inaccessibility of defendant's website. Due to defendant's failure to build the website in a manner that is compatible with screen access programs, plaintiff was unable to understand and properly interact with the website and was thus denied the benefit of purchasing the nutritional supplements that plaintiff wished to acquire from the website. The law requires that the defendant reasonably accommodate plaintiff's disabilities by removing these existing access barriers. Plaintiff has been, and in absence of an injunction, will continue to be injured by defendant's failure to provide the online content and services in a manner that is compatible with screen reader technology. Defendant's denial of full and equal access to and enjoyment of the goods, benefits, and services of the website has caused plaintiff to suffer an injury. In fact, due to plaintiff's inability to purchase nutritional supplements, which is a concrete and particularized injury, and is a direct result of defendant's conduct. Despite this direct harm and frustration, plaintiff intends to attempt to access the website in the future to purchase products and services the website offers, and more specifically, nutritional supplements if remedied.
These words, all of these paragraphs we just read, if someone does not have a litigation background, you would just read them and you would think, well, the plaintiff is just saying she was hurt, she wanted to use the website, she's going to go back to the website, just filling up the page with words. But really, all of these words are here for a reason, and the reason is that the complaint could be subject to dismissal without them. Remember, the ADA provides for injunctive relief. It doesn't provide for damages. So for an ADA claim to survive, you have to be able to show the court that it would be appropriate and proper for an injunction to be entered. What is an injunction? An injunction is the court either requiring someone to do something or requiring someone to refrain from doing something. But in this case, an injunction under the ADA context would be the court entering an order telling the defendant that they have to comply with the ADA. Now, if the plaintiff didn't intend to go back, didn't ever intend to use the product again in the future, isn't going to be harmed if there's a continuing ADA violation, well, then the injunction can't do anything for her. It can only do something for her if she's going to go back and use the product once the ADA violations are remedied, right? This goes back again to subject matter jurisdiction. If the plaintiff's never going to go back to this website, then an injunction from the court is not going to help her at all, and the court has no subject matter jurisdiction. So all of these words that we just read, at the end of the day, it's the plaintiff putting the ink on the paper that needs to be put there in order for this to be a lawsuit that would not be subject to basically immediate dismissal.
Nature of action. The internet has become a significant source of information, a portal, and a tool for conducting business, doing everyday activities such as shopping, learning, banking, researching, as well as many other activities for sighted, blind, and visually impaired persons alike.
All right, now, unlike the wording up till now, this, to my view, is gratuitous. Talking about what the internet is and what the internet does and what people do on the internet, I mean, to me, it's pointless. But it is the kind of language that you see a lot of in ADA website lawsuits in particular. A lot of language about how important the internet is and how people rely on the internet. I mean, you know, whatever, true, I guess, but not critical to the survival of an ADA lawsuit.
Blind and visually impaired users of Windows operating system-enabled computers and devices have several screen reading software programs available to them. Some of these programs are available for purchase, and other programs are available without the user having to purchase the program separately. Job Access with Speech, otherwise known as JAWS, is currently the most popular, separately purchased and downloaded screen reading software program available for a Windows computer.
Okay, so this is getting into the crux of explaining what the perceived ADA violation is and why it's a problem for the blind. So the blind use screen readers, JAWS and others, in order to make use of websites. And you'd be surprised that, you know, if the website is properly compatible with screen reading software, it can be very accessible to the blind and the visually impaired. And what this lawsuit is saying is that by not complying with the WCAG 2.1 guidelines, which are sort of the de facto guidelines on how to become compatible with screen reading software, the defendant is violating the ADA, because if you don't do this thing, screen readers won't work with the website. If screen readers don't work with the website, the blind and the visually impaired cannot use the website. By the way, I am constantly being approached by people who believe that they are ADA compliant for the blind and the visually impaired because they have a little widget, a little thing on the bottom corner of their website that allows the user to change the font or change the contrast. And those things are great, but for someone who's totally blind, they're useless. So that's not really what these particular lawsuits are alleging or are about.
Common barriers encountered by blind and visually impaired persons include...
I mean, now this is just a list of barriers that are commonly encountered by people who are blind on websites that are not ADA compliant. So, I mean, look, broken links, lack of explanation of what's in a photo, you know, all types of issues to do with the cart when you're on a shopping website. But these are all, you know, very much common issues that you see in every one of these cases.
Statement of facts. Defendant is a company that owns and operates the website, offering features which should allow all consumers to access the goods and services and by which defendant ensures the delivery of such goods throughout the United States, including New York State.
So again, here we have a personal jurisdiction basis for alleging that the defendant is delivering goods into New York State. That allegation is being made again in furtherance of the argument that there is personal jurisdiction over this particular defendant.
The website contains access barriers that prevent free and full use by the plaintiff using keyboards and screen reading software. These barriers include, but are not limited to, missing alt text, hidden elements on web pages, incorrectly formatted lists, unannounced pop-ups, unclear labels for interactive elements, and the requirement that some events be performed solely with a mouse. The website also contained a host of broken links, which is a hyperlink to a non-existent or empty web page. For the visually impaired, this is especially paralyzing due to the inability to navigate or otherwise determine where one is on the website once a broken link is encountered. Specifically, there is more than one main, navigation, and content info landmark without unique label.
So again, I mean, now we're getting repetitive, right? Just saying that the access barriers are on the website. It's not compatible with screen reading software.
Landmarks must be uniquely identifiable. When there is more than one landmark of the same type on the page, additional labeling is needed to allow users to differentiate among them. These access barriers effectively denied plaintiff the ability to use and enjoy defendant's website the same way cited individuals do.
So this is the hub, right? This is really the crux of any ADA lawsuit, but in this case, a website ADA lawsuit. These access barriers effectively denied plaintiff the ability to use and enjoy defendant's website the same way cited individuals do, right? Just like steps prevent somebody who is in a wheelchair from entering a building the way those who are able-bodied can, or an inaccessible bathroom prevents somebody who is disabled from using the restroom facilities in the way that somebody who's able-bodied can. The lack of this WCAG compliance on the website prevents people who are blind and visually impaired from using the website the way a sighted individual does. That's the crux of the allegation here. Now, I will say this. Because the ADA itself doesn't say these things, you know, the ADA has a broad remedial purpose to prevent discrimination against the disabled, which everyone can agree is a fantastic and appropriate purpose for the law. And it has these general anti-discrimination provisions which say that effectively that a business has to implement policies and procedures that are necessary in order to accommodate the disabled, which is great. The issue that a lot of businesses have, and the complaint that a lot of businesses have when it comes to this issue, putting to the side complaints about the person who's actually suing them and that person's motives, which many businesses that are sued question. The problem that many businesses have is that unlike, for example, having an accessible parking space, having a ramp, having an accessible bathroom, which are in the law and which are open and obvious even to small business owners, nobody has an excuse for not knowing that they have to do those things. This website issue has developed only recently, relatively recently, really since COVID, I would say, has it really developed as a practice area, although some cases were around before COVID, but since COVID is really when it's developed. And for a small and medium-sized business owner, there's often just no way to know that these requirements are out there unless you have just a fantastic IT person who's completely up to speed on these issues. So this is definitely a common complaint, is obviously I would have done this, obviously I would have made my website compatible with screen reading software and accessible to the blind if I even knew that that was a thing. So this is to me an understandable complaint, is the lack of notice, the lack of prior notice that websites have even become an issue under the ADA. They weren't years ago.
Plaintiff intends to visit the website in the near future if it is made accessible. Defendant has denied plaintiff, along with other blind or visually impaired users, access to defendant's website, and to therefore specifically deny the goods and services that are offered to the general public. If the website were equally accessible to all, plaintiff could independently navigate the website and complete a desired transaction as cited individuals do.
Getting a little repetitive, but you understand what's going on here, and if you read an ADA lawsuit yourself, you will understand there's that there is an effort to very clearly and repeatedly allege that the plaintiff wanted to go on the website. There's a product that the plaintiff wanted to purchase. There's a reason the plaintiff wanted to purchase that product. The product is sold into New York by the defendant. And if the website is made ADA compliant, the plaintiff will go back on the website in order to transact business as a cited person could do. So you understand now that these allegations are not only made in order to explain what the lawsuit's about, although obviously that's what they're doing, but also very specifically to get the correct elements into the complaint so that the court has jurisdiction and that the complaint is not subject to immediate dismissal.
Plaintiff alleges that defendant has engaged in acts of intentional discrimination, including but not limited to the following policies or practices.
And again, here we just have more of the same. We had it before. These were the specific allegations against this website. In particular, the plaintiff probably got an expert report. I don't know specifically in this case. I have had many cases against the law firm that filed this case, and against many other law firms who, on the plaintiff side, I know usually get an expert report. So this plaintiff probably had an expert report, and that list that we just saw of allegations about this lawsuit, this website in particular, probably came directly from a list that was provided by an expert who looked at the website before the case was filed.
Although defendant may currently have centralized policies regarding maintaining and operating the website, defendant lacks a plan and policy reasonably calculated to make them fully and equally accessible to and independently usable by blind and other visually impaired consumers.
Again, the plaintiff is now implicating the policies and procedures sections of the ADA. So when you look at an ADA physical barrier to access case, there's no ramp, there's no accessible parking, there's no accessible bathroom, the counter heights are too high. You will see very specific sections of the ADA that are implicated. If there's no access aisle, the plaintiff will say there is no access aisle in violation of the 2010 ADA implementing regulations section, whatever the specific section is, right? They'll do that for each and every alleged barrier. Here, we just had a list of things that are allegedly wrong with this website, followed by a statement that the defendant doesn't have the policies that are necessary in order to remove these issues and to make the website accessible to the blind and the visually impaired. So the plaintiff is not relying on in these website ADA cases, the plaintiff is not relying on a specific part of the implementing regulations, which are the regulations that say how you comply with the ADA, but is instead specifically relying on a very broad policy and procedure argument that these ADA violations violate a policy and procedure requirement that the defendant has. Hopefully that's clear.
There's some class action allegations plaintiff, on behalf of herself and all others similarly situated, seeks to certify a nationwide class on.
All right, so again, these are just the class action allegations. I don't know of a single ADA case that's been certified as a class action, but many of them are filed this way.
First cause of action violations of the ADA.
Okay, so basically from this point forward in this lawsuit, there's going to be a first cause of action. The words are just going to repeat. The factual words are just going to repeat. There's going to be some technical discussion about the ADA and what it requires, New York law and what it requires, and then an allegation that the facts that have been set forth, right, by the plaintiff in the rest of the lawsuit establish that what the law requires has been violated. I mean, that's going to be the allegation. So we're going to have a first cause of action in this case and basically in every ADA case for violation of the ADA. which is going to end with the plaintiff asking for an injunction requiring the issues to be fixed and for attorney fees. Then, at least in New York cases, and in this case, you're going to have counts 2 and 3 under the New York State and the New York City laws. And then there was a declaratory relief count. But the bottom line is, once you get past the general allegations when you're reading a complaint, then you start looking at the counts. You're going to see a count for violation of the ADA. You may then see counts for violation of state laws if you're in a state or you're sued in a state that has state laws that are companions to the ADA. But at the end of the day, it's all saying the same thing. The plaintiff wants attorney fees, the plaintiff wants the issue fixed, and in a state where it's available, the plaintiff wants some additional money. That's what it's about. So when you look through one of these cases, now hopefully you will be equipped to understand what it is that you're looking at, why the plaintiff is alleging the things that they're alleging, because all of it has a pretty specific purpose, and hopefully that sort of demystifies the document for you a little bit. And again, if you're sued in one of these cases, a company can't represent itself in court, get a lawyer who is competent to handle one of these matters, because in my opinion, the worst mistake a business owner can make after being sued in one of these cases is to hire someone that just is totally unfamiliar with this area of law. I've been hired in cases where the first lawyer hired really knew very little, if anything, about how you handle these particular cases, and they created a mess that I had to sort of clean up. Whereas a lawyer who's skilled in this area will usually have resolved many cases with the plaintiff's lawyer, because there's only a small number really of regular plaintiff's counsel in these cases, and will know how to sort of end this matter as cheaply and as efficiently as possible, leaving the business in a condition, leaving the business's website in a condition such that these types of cases won't happen again. And so that's my last piece of advice here in this video, is that if you get one of these lawsuits, good thing you can look through it and you can kind of make heads or tails of it, hopefully after this video, a little bit more than you could before. But whether it's me, whether it's someone else, doesn't matter. Find yourself an experienced lawyer in this field so that your business can have the risk properly managed and can have the lawsuit ended just as efficiently as possible.